to pleading, alternative pleading from American jurisprudence. Greetings to you all. Let's get started. But before we do, just to remind everyone, this is strictly for the entertainment educational purposes of this broadcast, not to be used, misconstrued, or abused for anything legal, lawful, personal, private, financial, tax, business, or otherwise. So please don't do this at home. That said, still waiting for the notification to come through. Not sure how many people got it or not, but it seems like it's going to be a little bit thin here. Let me give it a couple more minutes here, unless I get people through. It's going to jump to the intro. We'll be back in 2 minutes.
Shagahippy 1776 has donated $10 and says much love everyone.
All right. Well, it looks like notifications didn't go out, but nevertheless, I guess we can get started here. Let's do it. So we've already had the disclaimer. If not, you have to go back and watch that. But we're going to get started with pleading and alternative pleadings. So one other thing is at the end of okay, there we go. Yep, at the end of this broadcast here, we're going to try a little experiment here with a members only live stream transition. We're going to see how that feature works. And we'll give it a shot and see. That's all I can say. So let's proceed. Starting with our overview here, we're going to be going over from sections 57 to 66, so it's not a big presentation here. We have the alternate allegations, exceptions, the use of or and or. Then we'll go over the statements of claim, the sufficiency of pleading, inconsistent claims or defenses, which you will see here. This is really gets a little bit complicated. Counterclaims and third-party claims, inconsistency with pleadings in subsequent case, and judicial estoppel, and limitations on alternative or inconsistent pleading. 64 is going to be a fun one. Let's get started. So, alternate allegations. Pleading should not allege two or more alternative statements unless authorized by jurisdiction rules. So, not allege two or more. So you can have one alternative here. Pleading should not allege two or more alternative statements. When challenged by demurrer, as we went over in the previous presentation, pleading is construed against the pleader. And as we saw there, with the rule of too many and the rule of never too many. If any allegation is insufficient, the entire pleading is stricken. So again, if any of the allegations is insufficient, through the demurrer here, the entire pleading is stricken. and not an alternative if allegations relate to the same cause of action. So it's not an alternative pleading if it's relating to the same cause of action. So we have to have a different cause for it to be an alternative pleading. Let's get into this a little bit deeper. So an observation here. When alternative pleading creates uncertainty, remedy is to move to require plaintiff to elect which cause of action to pursue. So they're saying it could be this, and the alternative, it could be that. And when it starts to create uncertainty, the remedy is to make a motion to move to require the plaintiff to elect which cause to pursue. Pick one. Then there's the exceptions. Alternative pleading allowed when pleader is uncertain of grounds for claim or defense. When the plaintiff doesn't know exact relationship between the multiple defendants. See, these are some exceptions here. So it's the alternative pleading is allowed when the pleader is uncertain of the grounds and when the plaintiff doesn't know the exact relationship between multiple defendants. And when uncertain which facts to allege, but the adversaries are liable under either set of facts. So one way or another, these guys are liable. And that's where the alternative pleading comes in. It's when there's a little bit of uncertain as to which facts to allege. Now we're on to the use of or and or. Or is not in the alternative. So it's this or that is not in the alternative if the allegations legally mean the same thing. So the or being used is just maybe another example of, not an alternative of. That's critical. If meanings differ, some jurisdictions construe pleading only as the latter alternative. So if the meanings differ, they pick the second or the last one. Example, knew or might have known by reasonable care the pleading only the latter allegations. Wow. So really the knew here would be redundant. Might have known also would be known. Known or might have known. So that's where the or comes in. And then when you're using that disjunction, it really the pleading only is looking at the latter alternative here, or latter allegation, I should say. So conversion by one or two parties is insufficient without alleging a close relationship. Oh, wow. So you have to allege the close relationship. And or in pleading is disfavored. So they don't like the and or in pleading. This is a terrible thing for pleading. In some jurisdictions, and or subjects pleading to a demurrer attack. So the facts not being clear enough, it seems, would open it to demurrer attack. And if you're not too sure what demurrer is, we went over that in last night's presentation and get a really nice historical and analysis of what demurrer is and what it functions as today, as the device it is from common law. So, statements of the claim, part one. Federal rules permit setting forth two or more statements of claim or defense alternatively. It can be in one count or defense or in separate counts or defenses. So that's how the statements of claim, they could be in one count or defense per statement here or in separate counts or defenses. Permitted regardless of consistency of claims or defenses. And read with rule permitting joinder of as many claims as needed against the opposing party. So federal rules expressly permit pleading of both alternative and inconsistent claims. That sounds contradictory here to have inconsistent claims. We'll get more into that. So the statements of claim part two. Plaintiffs with alternative claims cannot be required to choose which claim to rely upon. Permissible because no danger of double recovery when inconsistent theories in same case. So even if they win with both, they can't get double recovery. So there's really no danger. defendant in doubt may set forth two or more statements of defense alternately. The court commits error when compelling defendant to elect between defenses. So the defendant is in doubt. They can set forth two or more statements of defense. And a court would commit an error, which would be, under appeal would be recognized here, when they compel the defendant to elect between defenses. Indeed, sometimes I've seen this, where a court will commit that error. And if you don't call them on it, it will stand. If you call them on it, they'll usually backpedal, but that's neither here nor there. So generally, statements of claim, part 3 here, federal rule requiring particularity in fraud pleading does not preclude alternative pleading in fraud cases. So both the plaintiff's and defendant's rights to plead in the alternative are matters of procedure governed by federal rules. So in a diversity action, state and federal, right? State law requiring election of claims or defenses is inapplicable. So here's our practice tip to start with here. Although the joinder of two alternative causes of action is proper, so bringing together two alternative causes of action, the court may not have jurisdiction over one of the claims by reason of the fact that it has jurisdiction over the other claim, such as when the second cause of action is in no way arises out of or is incidental to the first. Wow. So they could have, this is a practice tip, although you can have a joinder, the court may not have jurisdiction over one of the claims, so be careful with the joinders. And observation, although the rule permits a party to set forth two or more statements of a claim alternatively, the claims must nonetheless be stated simply and clearly. The provisions of the rule do not relieve the pleader of the obligation to set forth a short and plain statement of each claim for relief. Right. Hey, I just noticed here we got that super chat. Well, thank you, Shaggy Hippie. Indeed. Stick around. We're going to be on to the try out this members only live stream for all the members here. And I saw there's someone else that joined in for the members only, so hopefully they'll be here for it. This is just going to be a test anyways, nothing really super duper yet, but we're just going to see how it works so we'll know what to set up. So we're on to the sufficiency of pleading. Let's see, do we get all the... Here we go. Yeah, we got all these here. So our sufficiency of pleading, when two or more statements are made in the alternative, and one of them, if made independently, would be sufficient. A pleading is not made insufficient by the insufficiency of one or more of the alternative statements. So even if you have alternatives, as long as it only requires one to be sufficient. Even if some of the others were insufficient, as long as that one was sufficient independently, then that would stand. And a complaint is sufficient if only one of several alternative claims sets forth facts on which relief can be granted. So it's sufficient with only one of several alternative claims. So the practice tip, when multiple defenses are pleaded, if any one of them is sustained, it is fatal to the plaintiff's cause of action. The fact that the plaintiff did not expressly label claims in the complaint as being made in the alternative did not preclude its assertion of alternative claims, where it could be reasonably inferred that the plaintiff intended to do so. Let's see here. So the fact that the plaintiff did not expressly, did not preclude its assertion. Okay, where it could be reasonably inferred. So again, to the substance, not to the label. Nonetheless, I wouldn't test the courts. That's why we're going over this. Let's go on to section 62, the inconsistent claims or defenses. The federal rules permit stating as many separate claims or defenses as party has regardless of consistency. Claims may be based on legal, equitable, or maritime grounds. And inconsistent claims may be pleaded even within the same count. This is inconsistent claims. So let's see here. Example, product liability action. A plaintiff may allege negligence, breach of warranty, strict liability, absolute liability, deceit, and nuisance. So we have all these, I don't know if these are inconsistent claims, but they're all within the same count. All right, let's move along. We have inconsistent claims or defenses, part 2, in our observation. Inconsistency in pleading may lie either in the statement of facts or in legal theories adopted. So the party is not required to elect which alternate legal theory to proceed on. So the party is not required to elect. The plaintiff may state alternative claims against multiple defendants if it includes clear liability statement and shows inability to determine which defendant is liable. Okay, so liability, inability, and liable. So the plaintiff may state the alternative claims against multiple defendants. Wow, so that's pretty complicated there. Alternate claims against multiple defendants. If it includes clear liability statement, so that's one of the things, a clear liability statement, and shows inability to determine which defendant is liable. Wow, okay, so if you don't know which of them it is, then you can have alternative claims against multiple defendants. That really gets starts to get confusing, but I get it now. So the practice tip is when the plaintiff hasn't decided if cause of action is governed by foreign or domestic law, it may state separate claims under both. So if you're not sure, if you haven't decided if it's governed by one of the two, you may state separate claims under both. Separate claims under both. So I guess you would customize them for each of the different jurisdictions. Plaintiff may allege liability of a single defendant in multiple alternative capacities. This is key. We've heard of this before in official and personal capacities. The defendant may plead inconsistent defenses, deny allegations while advancing affirmative defense. So the defendant may plead inconsistent defenses and deny allegations while still advancing an affirmative defense. Okay, so we're on to the counterclaims and third-party claims. The defendant may assert counterclaim inconsistent with the affirmative defense raised in the same answer. So here's an example. The defendant in a diversity action may claim, the diversity is going to be in two different jurisdictions like state and federal. So the defendant in the diversity action may claim contract does not exist or was fraudulently induced and simultaneously counterclaim for breach. Wow. So it's inconsistent because if it doesn't exist, you can't make a counterclaim. Fraudulently, same with it being fraudulently induced, I guess, for breach of a fraudulently. So yeah, you see where the inconsistency comes in. But you can do this because you're not sure. All you know is that the defendant got harmed, or let's see. Okay, yeah, the plaintiff claims are being harmed, and the defendant is claiming that I have no idea how he got harmed. Either doesn't exist, or maybe this is something that they fraudulently induced, and simultaneously counterclaim for breach because even if it was real, then they did something to breach it, so now I'm not going to be liable. Something of that nature. The defendant may deny liability and bring claims against other defendants. See this counterclaim for breach, arguing alternatively that a judged liable third-party defendants are liable as well. So if he's judged liable, the third-party defendants are liable as well. Whew. Here's our observation. Inconsistent counterclaim and third-party claim does not preclude bringing in third-party defendant. Just bring everyone into the party here. And here we go. The inconsistency with pleadings in subsequent cases. So this is a good one. Assuming res judicata or estoppel do not arise, inconsistent allegation in prior cases not binding in subsequent case. So unless there is some kind of standing here, past judgment that that's been ruled already, or in a judicial estoppel, that an inconsistent allegation in a prior case is not binding in a subsequent case. So the inconsistent allegation doesn't really, it won't be binding in the subsequent case. The party may raise defense inconsistent with position taken under oath in a prior proceeding. So now you said before under oath one thing, and now you're saying under oath another. But you may raise a defense that's inconsistent like that. However, the inconsistent statements may have evidentiary value as admissions, convincing, persuasive, or of little weight. Here's our practice tip, though. The inconsistent allegations in different lawsuits are admissible in evidence, but statements from earlier pleadings filed in the same lawsuit and later amended are not. So if it was, pleadings were made stating one thing and then amended, you can't refer back to the original pleadings. You'd have to get back to the, you can only refer to the amended ones. The original ones, if they were amended, the original ones will be ignored. So, inconsistent statements should be considered with any other evidence offered in explanation. So, that's the way it is. The inconsistent statements, even if they counter what was given under testimony in a prior case, they should be considered with any other evidence. So, got to keep an open mind. Now we're on to the judicial estoppel. So with judicial estoppel, the doctrine prevents the party from asserting a position inconsistent with positions successfully taken in the same or prior litigation. It's especially when inconsistent position would prejudice an opposing party. This is where we have a position before in a previous case, and now that would prejudice one party or another, then it starts to have some effect. Does not conflict with the right to plead inconsistent claims under federal law. So here's our key distinction. A party is barred only from asserting a position inconsistent with a position already adjudicated and accepted by a court. So only is inconsistent that's already been adjudicated and accepted by a court. Adjudicated and accepted. So again, and we have a supplement here case for the judicial estoppel. The litigant not permitted to advance a ground in one lawsuit prevail on that ground, and in a later lawsuit against the same party seek judgment based on repudiation of earlier position. Talk about hypocrisy. But he's not permitted to advance the ground in one lawsuit, prevail on that ground, and in a later lawsuit against same party seek judgment based on repudiation of the earlier position. Yeah, wow, that takes some real wow. 2011, Walton versus Bayer Corporation. That'd be interesting to look into a little bit more. Okay, limitations on alternative or inconsistent pleading. All alternative statements must be made subject to signing obligations in rule. Party not at liberty to set forth variant statements unless legitimately in doubt as to what evidence will show. The party is not forced to select a single theory to exclusion of all others if unsure of basis for recovery or defense. So you're not forced to a single theory to exclusion of others if unsure of the basis for recovery. Improper practice warning. Combining legally insufficient theory with viable theory is improper. At best, this burdens complaint with surplusage. And at worst, it may cloud actionable theory to a point where it fails to state a claim upon which relief may be granted. Stay away from the surplusage. Very important in the pleadings. All right, so here's a summary of the alternative pleading basics. Here it's allowed when pleader is uncertain of the grounds. Then you can do your alternative pleadings. Must be authorized by jurisdiction rules. Construed against the pleader when challenged, especially by a demurrer, which would be looking at either the saying that there's the law question of law or the question of the facts in law is got to be decided before they get into proving any of the evidence. And alternative allegations must relate to different causes of action. So, again, the different causes for different alternatives. The inconsistent claims, they're permitted under federal rules, as we saw. There's no requirement to elect between the theories. They can be pleaded within the same count, too, and there's no danger of double recovery. That's why they do allow it. Then there's limitations and considerations. The judicial estoppel prevents inconsistent positions in different proceedings. This is where we have that res judicata. And all statements subject to signing obligations. They must be stated simply and clearly and cannot combine insufficient with viable theories. There's that surplusage. So for our conclusion, the alternative pleading is a fundamental procedural tool designed to ensure justice when facts are uncertain. Of course, it's confusing in and of itself, but as you see, it doesn't prevent accessing justice when facts are uncertain. Federal rules broadly permit both alternative and inconsistent claims to prevent a party from being trapped by a single, unproven theory. However, this power is not without limits. Pleadings must still remain clear, concise, and grounded in genuine uncertainty, while respecting doctrines like judicial estoppel that maintains the integrity of the judicial process. So our key takeaway is that use alternative pleading strategically to cover all viable theories, but always with precision and a good faith basis in fact to ensure your claims withstand procedural challenges. All right, and with that said, brings us to the end of the presentation. We're going to go over a little primer I also made here. I guess we'll use this for the members only live stream. Let me see if I can trigger this feature here. It says here, okay, let's see here. All right, get to put a heart there. Thank you again, Shaggy Hippie. Much love to you and everyone. There it is, members only live stream for all channel members. Starts in 5 minutes. All right, that's what we get. That's what it says here. We'll hit schedule and see what it's doing. 5 minutes. Get excited. 5 minutes until members only. You'll be redirected automatically. All right, so we got 5 minutes. I guess I could get the timer to give us 5 minutes here. Let's take a look over here. The timer. Jeez. Refresh cache. There we go. That's still not going to do it, huh? All right, one more time. I guess we can put some music on while we're doing all this.